From today on, make the rest of your life the best of your life. Real Estate Settlement Procedures Act, RESPA. What is it? In order to give sellers and buyers of real estate comprehensive disclosures on settlement costs, the United States Congress passed the Real Estate Settlement Procedures Act, RESPA, in 1975. Additionally, RESPA was designed to outlaw bribes, restrict the usage of escrow accounts, and end abusive activities in the real estate settlement process. Currently under the purview of the Consumer Financial Protection Bureau, CFPB, RESPA is a federal statute. Here we will share a comprehensive knowledge of the Real Estate Settlement Procedures Act, RESPA. Subscribe to our channel before we take a start. Congress first passed RESPA in 1974, and it went into effect on June 20, 1975. Over the years, numerous revisions and alterations have affected RESPA. At first, the U.S. Department of Housing and Urban Development, HUD, was in charge of enforcement. In 2011, the Dodd-Frank Wall Street Reform and Consumer Protection Act transferred those duties to the Consumer Financial Protection Bureau, CFPB. Since its establishment, RESPA has governed mortgage loans secured by single to multifamily homes. The purpose of RESPA is to inform borrowers about the settlement expenses they will incur and to do away with referral fees and kickbacks that may drive up the price of getting a mortgage. Most purchase loans, assumption loans, refinances, property renovation loans, and home equity lines of credit, HELOCs, are among the loan categories covered under RESPA. Extensions of credit to the government, its agencies, or its instrumentalities are exempt from RESPA, as are circumstances in which the borrower intends to use the property or land principally for commercial, agricultural, or business purposes. Lenders, mortgage brokers, and home loan servicers are required by RESPA to provide borrowers with all relevant information regarding the real estate transaction, settlement services, pertinent consumer protection legislation, and any other information pertaining to the price of the real estate settlement procedure should all be disclosed. The borrower should also be informed of any business links that closing service providers may have with other parties involved in the settlement process. What is prohibited under RESPA? Certain tactics are prohibited by RESPA, including recommendations, kickbacks, and unearned compensation. For instance, Section 8 forbids anybody from offering or accepting anything of value in return for recommending a settlement service company. Additionally, it limits the usage of escrow accounts by preventing sellers from requiring title insurance firms and forbids loan servicers from requesting unreasonably large escrow accounts. Brokers and agents may trade fair compensation for products or services from other settlement service providers under a specific exception permitted by RESPA, provided that the agreements comply with legal and regulatory requirements. Joint marketing initiatives between a lender and a real estate broker are permitted by RESPA as long as the advertising expenses incurred by each party are commensurate with the potential value of any products or services obtained in exchange. However, it is forbidden for one party to pay more for advertising than their pro rata share. Events may also be forbidden from being sponsored if one party utilizes the event to promote or advertise its products or services. When one party charges the other more for marketing materials than the fair market value of the marketing services rendered, real estate brokers and title agents are prohibited from entering into market service agreements. If another settlement service provider is not receiving fair market value for the space it is renting, the first settlement service provider may not rent it. Agents referred by real estate brokers to their affiliated mortgage company are not eligible for compensation. Brokers are not permitted to pay other brokers referral fees for bringing clients to their establishment. These cooperative payments are forbidden since they are thought to be kickbacks. Mortgage lenders are prohibited from providing local real estate agents with any kind of referral compensation in exchange for promoting homebuyers to their loan products. It is against the law for real estate brokers to recommend clients to a connected title company without telling their clientele of this connection. The fees the title firm charges for its services, as well as the broker's financial stake in the title company, must be disclosed in full. It's also important to let customers know that they are under no obligation to employ the title business that was recommended to them. Title insurance companies and real estate brokers are not allowed to form a joint venture in order to receive commissions on recommendations. Borrowers cannot be forced to choose a specific associate settlement service provider by their lenders. They may nevertheless offer monetary rewards for doing so. For instance, a buyer of a house can be eligible for subsidized use of related services. A class action lawsuit filed by homeowners accusing the National Association of Realtors, NAR, of inflating realtor commissions was settled in March 2024. Future commissions are probably going to be far lower if the court approves the settlement. Enforcement protocols for infractions of RESPA in cases where bribes or other unlawful behavior happened during the settlement process. A plaintiff has up to 1 year to file a lawsuit to enforce violations. Before filing a lawsuit, borrowers must follow certain procedures if they have a dispute against their loan servicer. The borrower is required to send a written message to their loan servicer, outlining the specifics of their problem. After receiving the borrower's complaint, the servicer has 20 business days to provide a written response. The service provider has 60 working days to resolve the matter or provide justification for the account's present standing. Until the problem is fixed, borrowers must continue to make the appropriate payments. 9. A plaintiff may file a lawsuit against their loan servicer for particular irregularities within a maximum of 3 years. Any federal district court that is located in the district where the property is located or the alleged RESPA violation occurred may hear any of these lawsuits. If you don't hire a lawyer for the duration of your real estate transaction, you should do so as soon as possible. If you think there has been a RESPA violation, you can get assistance navigating the legal system from a real estate attorney. Reactions to RESPA. RESPA's detractors claim that some of the harmful practices, such as kickbacks, that the law is intended to outlaw nevertheless take place. Lenders who cooperate with title insurance companies and offer captive insurance to them are one example of this. An entirely owned subsidiary of a bigger corporation, a captive insurance company writes insurance policies just for the parent and does not cover other companies. Although clients are obliged to sign paperwork stating they are free to choose any service provider, critics claim this is effectively a kickback system because customers typically opt to utilize the service providers already affiliated with their lender or real estate agent. Numerous attempts to amend RESPA have been made in response to these critiques. One suggestion is to do away with the choice for clients to select any service provider for every service. A system where services are bundled but the lender or real estate agent is directly responsible for covering all other fees would take the place of this. The benefit of this arrangement is that it would compel lenders, who are always more powerful financially, to look for the best deals on all real estate settlement services. The Real Estate Settlement Procedures Act, RESPA, offers protection to whom? The purpose of the Real Estate Settlement Procedures Act, RESPA, is to safeguard applicants for mortgage loans. But not every kind of loan is protected by RESPA. RESPA does not apply to loans used for business or agricultural purposes that are secured by real estate. What data must be shared according to RESPA? Under RESPA, different disclosures must be given to borrowers at different periods. You must first receive an estimate of the total settlement service charges that you will probably be required to pay from the lender or mortgage broker. Actual cost may differ from this estimate, which is a good faith estimate. When you apply for a loan, or within the next 3 business days, if the lender or mortgage broker anticipates that another party will be handling the collection of your mortgage payments, commonly known as servicing a loan, they must also give you a written disclosure. What made RESPA passable? In an attempt to curtail the usage of escrow accounts and outlaw unethical practices in the real estate sector, like referral fees and kickbacks, RESPA was passed. Working with a reputable, licensed real estate agent or broker who can help you navigate the process can be beneficial when purchasing a house. Likewise, it's crucial to work with a trustworthy lender, whether you're refinancing an existing mortgage or taking out a loan against the equity in your house. RESPA is intended to shield prospective and current homeowners against deceptive activities, while interacting with real estate brokers, lenders, agents, and associated businesses. It is intended to be used in conjunction with other regulatory rules. This finishes today's video. Do let us know if you have any questions in the comments. If you're interested in watching more videos like this, then do subscribe to us. Thanks for watching. I'm giving you some news you can use.